Hey guys, it's Squid. Welcome back to my channel. Holy crap, how's everybody doing today? Sorry about the last stream. The little was trying to destroy my microphone, and she was throwing one heck of a tantrum. So we had to call it a we had to call it for the morning. I wanted to finish the stinking I wanted to finish that. I really, really wanted to finish that document today, but it looks like it will have to wait until tomorrow. Oh, we're almost through it, because then once we're done reading the complaint, we can get to all the juicy shit. And Robin, thank you for being the one to let me know of this document. I checked the docket a little while ago, and there was nothing there. And then all of a sudden, I get a comment that says Bubbles filed a new. And I didn't read the rest of it, because I'm like, oh, that's all Bubbles filed was all that needed to be said. So, like, girl, sometimes less is more. When you want something, this is not the where the squeaky wheel gets the grease. This is where the squeaky wheel gets contempt. Oh, I just can't. Sometimes, man, I'm like, why would you do that? Why? Just why? And how is everybody doing today? Oh my goodness. It's been such a busy day. I got a lot accomplished this morning. Except for a stream. I only lasted 50 minutes and got like 20 pages done. We killed it. Yeah, hey Crystals, how are you? I think that's kind of the case too. Yeah, it just is like that can't either that, or he is completely losing his mind. And which may very well be the case too, because just like if you've heard him talk, the squeaky wheel get the hammer into the ground. I just think that, like, sometimes you just have to know when to stop. Like, it's fine to be loud, obnoxious. Like, it is fine, but you have to know when to stop. There are limits to everything. And I just think that he does not know his limits. Oh, thank you. It's definitely bright. It's definitely bright. Oh, I thought we were going to have a quiet stream. I sprayed the little's pillow with the lavender sleep stuff, and I tried to get her down for a nap. I got her in her room laying down, and she was good until right now. Yeah, and that's the thing. Like, at this point, he's doing his clients a disservice, which is kind of the worst part. Like, it's not that I'm a fan of them by any means, but, like, at a certain point... Help me. What do you need help with, boo? What do you need help with? Oh, girl, you still have peanut butter on your face. And then she takes over. It's just, yeah, Ammo's girl. I kind of had to call it a quick end, because it was like when she tried to knock my mic off the table, not once but twice. I was like, for my own sanity, I just had to stop. Like, oh, I heard that Elemental Bead ordered a no-show today. Yeah. All right. Well, we will get into what he said. Okay. There we go. So he has filed a motion today. And sometimes I'm like, hi. I'm like, what? Why? Just why? There are just some things that you just don't need to do. And I feel like this is one of them. I'm going to put myself there. All right. Motion for attorney's fees under 28 U.S. Code 1927. This is, why does he need attorney's fees? I thought he was pro bono. If he's not charging them anything, why does he want attorney's fees? Oh, so he can, that's right. So he can make money. Like, they're not paying him, but he still wants Jeremy to pay him. Oh, that's how this works. That's a good point. Like, yeah. That was my question too. Hello, Harry. Start canceled depot 15 minutes before it was supposed to start. Oi. Girl, out of your mouth, please. Out. Girl, we're getting at everything today. Oh, like, say Rule 26 one more time. Yeah. Make it make sense. Like, make it make sense. Yeah, bus fare. Like, 0 times 0 is 0. No matter how many times that you try to change math, the math is still the math. Girl. God. Baby squid raid. The defendants moved pursuant to... Baby girl, please stop. Here, you can have it this time. The defendants moved pursuant to 28 U.S. Code 1927 for an order that the plaintiff pay a reasonable attorney fee as a sanction for unreasonably and vexatious multiplying proceedings by falsely accusing the defendant's counsel of fabricating quotations from legal authority, as well as other misrepresentations in the plaintiff's opposition, document 80, to the defendant's recent 12B1 motion. Oh my God, this stupid 12B1 motion. He's the 12B1 motion just, oh my God. And at least, okay, in playing devil's advocate, in his defense, at least he did not use the stupid acronym. So we're making a slight improvement. Emphasis on slight. Document 80 was replete with misrepresentations to influence the court's view of issues and authorities raised in the defendant's 12B1 motion, as it was necessary to respond to ensure the court was not unduly misled. The defendants requested to leave to file a reply, document 83, which the court granted, document 84. The defendants thereafter filed a reply, document 87, addressing the misrepresentations contained in the plaintiff's 12B1 opposition. Plaintiff's misrepresentations thus resulting in multiplying proceedings by necessitating the request to file a reply, document 83, the court's ruling that document 84 and the reply itself, document 87. I don't know about the no motions from either side, but I did, he did say that not to file certain motions because they would be denied, like moving it to Gainesville. This is just, that's a good point. Yeah, that's a good point. It feels like he's trying to do that and using sanctions and attorney's fees as a guise for his response. So he gets to file 2 responses. But that's just me being... That's true. And that's why I think he will be sanctioned, is because he does not know when to keep his mouth shut. Despite people giving him free legal advice and people not lawyers, not paralegals, but just common sense of sometimes just shut up. like sometimes just shut up and not say anything. It's the best way of doing it. Hey, David, typical late to the party. Traffic, what a poop on the way home. Well, I'm sorry. Glad you're here, though. Yes, discretion is the better part of valor. And I don't know if the judge said no more specifically. He did say don't file a motion for to move it to Gainesville because it will be denied. But, If they didn't call in until 15 minutes before, aren't they on the hook for fees like lawyers, court, stenographer? I would think so, but once again, not a lawyer. This is where we all learn together. But I would assume so, because they didn't give them reasonable time, and somebody's got to pay for that. Like, I just joined. What did I miss? BM. Yes, Bruce is BBB. Bruce. Or Beelzebubbles, as some people like to call him. The last train to Gainesville. The no-show was for the state case. Yeah, I figured because they mentioned Stark, and Stark is, people had mentioned Stark, and Stark is the state case, not the federal case. So that's how I tell them apart. Anytime Stark is involved. That's true. This isn't for, yeah, he said no more summary judgment filings till after discovery is done. This isn't a summary judgment. He's skirting in between the lines. I wish the judge would just say no more motions until the hearing. But he's saying he's following the judge's orders, not filing summary judgment motions, not filing motions to move it or for reconsideration, but he still has to get his attitude in there. Like, oh. All right. Does everyone ever just want to go like, just why? Like, don't get me wrong. It's entertaining as hell to watch him write stupid motions. It is entertaining as hell to see a motion that makes very little sense to the average person. Even the average person is like, why are you doing this? Someone who has no experience in anything can look at this and go, why? Just why? Yeah, that's Tammy. This is a good point. The judge gave him an extension, 5 working days or 5 days of an extension to file a response to the sanctions. So instead of working his butt off to find case law and all that, he files this. The judge is, if I were the judge, I wouldn't be happy that said you asked for an extension of time so you could have more time to write a good motion, and instead while you're given more time for that, you file this. I just sometimes you just look at it and you just like, did you get dropped on your head as a baby? This was filed today. This was filed not too long ago, because I had looked at like 11 o'clock and there was nothing. So this was filed between 11 and 1:15. Or uploaded, not when it was filed, when it was put on the website, because there is a difference there's always a difference between when it's actually given to the court and when the court gets it online. Oh, this is just crazy. Memorandum in support. Oh, good Lord. 28 U.S. Code Statute 1927 provides, quote, any attorney or other person admitted to conduct cases in any court in the United States or territory thereof, who so multiplies the proceedings in any case unreasonably and vexatiously, may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. My problem with this is if he quotes a good code here. However, the fact that he's filed multiple motions that the judge said, Randy, you don't even have to file a response. He's the one who is filing unreasonably and like unreasonable motions. This is document 104. 104. Like, and we should go back and see what we have to go back and see how many were filed by each and what were originals and what were responses. But like, yeah, I hope Randy doesn't respond for at least after his deadline. Hopefully the judge will quickly deny it without Randy's input. Yeah, like I It's just, yeah, I heard that. It's crazy. Like, I know depositions can be stressful, but like, if you have nothing to hide, what are you scared of? If you think you're in the right, what are you scared of? If you think that you are the winner in this situation, why won't you answer questions? It's really not a hard thing. Like, I mean, if you think you're in the right, answering questions should not be that hard. Providing the evidence that proves you're right should not be that hard. It's my opinion. But he cites a good statute to be used against him. Under the plain language of the statute, 3 factors must be present in order to justify imposition of sanctions. An attorney must engage in unreasonable and vexatious conduct. Check. This, Sharon, this is document 104. And yes, some of them are judge's orders, but, you know. Yes. That's the long or the short of it. Confessions through projection. Yes. Chucky, that is a great way of putting it. Oh my goodness. Such unreasonable and vexatious conduct must multiply the proceedings. I'm not seeing how either side is doing that. The amount of sanction cannot exceed the cost of occasioned by the objectionable conduct. Fair. Smith v. Psychiatric Solutions, Inc., Northern District of Florida, 2012, quoting Norellis v. Denny's, Incorporated, 11th Circuit, 2010. More particularly, the term unreasonably necessarily connotes that the district court must compare the attorney's conduct against the conduct of a reasonable attorney and make a judgment about whether the conduct was acceptable according to some objective standard. The term vexatiously similarly requires the evaluation of attorney's objective conduct. See also Amlong, 500 Florida 3rd District, 3D at 1240, citing Black's Law Dictionary for the definition of vexatious, meaning without reasonable or probable cause or excuse, harassing, annoying. The projection is real because I think like this. Okay. These two things perfectly describe Bubbles' personality. From someone who has received multiple emails from him without when after being told not to email me. Y'all, I've told y'all about the ones where he emailed me. I was live when I got him, and I basically said Bruce emailed me again. He has not emailed me since then, so I don't want anybody to mess up the timeline or confuse the timeline. But from someone who has personally received emails from this man, these two words perfectly. Judge Davis is the trespass 5 and the thumbnail case judge. Oh, yeah. Oh my God. It's just, wouldn't you think it can't get any more ridiculous? Here we are. I thought it was going to be a quiet week document wise until he filed his response. And then we get this. Hey, LRG. Although the attorney's objective conduct is the focus of the analysis, the attorney's subjective state of mind is frequently an important piece of the calculus because a given act is more likely to fall outside the bounds of acceptable conduct and therefore be unreasonable and vexatious if it is done with a malicious purpose or intent. So much to say. Yes. Plus, this is one of the motions, and he's done this a couple of times, where he files a motion that perfectly describes his own behavior. And I would think he's called me biased, but when one side attacks you and the other side doesn't, you tend to lean more towards. But in all of these filings, he has the one that has seemed to have a malicious purpose, intent, and just he's perfectly describing his own situation. It's just. Hey, I have my favorites. Yes, it is. It's like he is talking about himself. Yes, right. This right here. Any reasonable lawyer would not call the other lawyer a scumbag and a dumb and a clown. Whether you think those things, I can think someone is a scumbag, but there is a difference of what you think, what you say, and what you write in an email that can be reproduced to a judge. All of those are different scenarios. It's just, I don't know. He argues against himself, and it's like he argues the case for Randy. Randy doesn't have to write a response to this, because this is a response to itself. He is wanting attorney's fees that he's supposedly not even charging, but yet argues what Randy would argue. He's being vexatious. Look how many. If I were Randy, I would literally go through the docket and be like, this was a motion that I didn't need to oppose. This was a motion I didn't need to oppose. This was a motion I didn't need to oppose. And look at the numbers. Yes, this case is dumb. Like, I get the original point of it. I do, but it's gotten so freaking out of hand. Like, it is. Yeah. So the big thing is he's asking for money. Yeah, he's asking for attorney's fees due to vexatious litigation from Randy, when he's the one filing all these motions. I think he's trying to lose his pro hoc vice status. I just think he is trying. Smith v. Psychiatric Solutions, Northern District, Florida, 2012, quoting Amlong and Amlong, PA v. Denny's, 11th Circuit, 2007. It is objectively unreasonable and vexatious to make false accusations accusing counsel of fabricating quotes from legal authority. An award, but Randy proved it. If I'm remembering correctly. And be it, I have somewhat of a shoddy memory sometimes. Brain surgery will do that to you. Like, side note, I'm having to go to the doctor soon because my whole, where my ulnar nerve is like tender to the touch. It doesn't hurt when I move, but like you touch it and it's almost like a shingles kind of feeling. It's, yeah. Memory is weird. But if I'm remembering even remotely correctly, Randy proved it in that motion, because I was like, ooh. Hey, Yeedy, where have you been? I've missed you, sir. Yeah, that's the only, like, I just, yeah, I'm the same way. I kind of, I asked Mr. Squid if I could go, because I've never spent a night away from my child ever, and but it's a little far of a drive. It's like 7 hours, 6.5 hours. Yeah. Okay. Randy did prove it. Okay. Yeah. I thought he did. And it was like, it looked like he got it out of a Cliff Notes book. I'm not sure what you would call that in the legal world, but, and he quoted that, which wasn't a direct quote from the original. I believe, and here's my thought process, and feel free to agree with me or disagree with me. my thought process is when he was looking at that Cliff Notes version of the case, he assumed, and this is where he went wrong, that what it was saying in that was a direct quote from the case. He quoted it as it was a direct quote, and it wasn't. But that's just my thought process, where he thinks he's right, and Brandy proved that he wasn't. It's like, yes, he did take a quote, but he took that quote from the Cliff Notes, which might not have been a real quote. Yes. Hey, mostly harmless fuzzball. Love the name. Catching up from 22 minutes ago, but this is not the kind of thing you should be doing when you're already facing a show cause hearing. Yes. When you have a hearing that the defendants are not even required to be at, but the defendant's attorney is, that is never, in my experience with watching and reading and just looking at our legal system, whenever the judge wants to talk to the attorney by themselves, that is not a good thing. Not a good thing. Oh, and Debbie, thank you. I will look at it and I will read it. My phone is nowhere. My phone is not in the room. Somebody has it. So, you know. Yeah. Bless his little heart. Too much bubbles equals a headache and a lower IQ. Yeah, I'm kind of like, I just. Oh, can I show the photo? The one where he called me Hobbit feet? I will read it when we are done with this. I will read it. Oh, thank you. Cash App and Debbie, let me get that. Hi, beautiful. So, who get that? Let's see. Come on. Debbie, thanks for the $15 Cash App. This is for my baby girl. We got stuff for your room. We can buy some stuff for your room. We already called Daddy. We already called Daddy. You'll see Daddy when he gets home from work, okay? She's such a daddy's girl. When we're Malin, when we are done reading this, I definitely will show it to you. He called me Hobbit feet. Actually, he said hobbits have bigger feet than me. An award of attorney's fees is warranted under 28 U.S. Code 1927, regardless of the outcome of the 12B1 motion, because the plaintiff multiplied proceedings by necessitating a response to the false accusations and misrepresentations. Although the court denied the defendant's 12B1 motion, the decision, document 103, did not address the false accusations claimed in the plaintiff's 12B1 opposition that the defendant's counsel fabricated legal authority, which alone is grounds for imposing sanctions. I don't think the judge agreed with him. Which is why I believe this will not be well taken. Avery, boo. Avery. It's okay, beautiful. This is where we're at today. She wants to call Daddy. Like, here, you can text him. Yep, you can text him. Baby, we can't. She wants to call her dad, and he's at work. She already talked to him twice today. Or called him twice today, answered once. See, Xiaovei, and my Chinese is not great. Xiaovei Wei Catering, Linkage Intermong Company, Xiaovei Wei Yang USA in civil action. District of Massachusetts. Okay, so Massachusetts only has one district. March 30th, 2018. Attorney Zhu, also admitted at the hearing on February 13th, 2018, that he wrongfully accused Attorney Murillo of fabricating evidence. The court finds that he should be sanctioned for this conduct under the court's inherent power to sanction parties for misconduct during litigation. See Chambers v. NASCO, Inc., 1991, holding that courts are invested with inherent power to impose sanctions for bad faith conduct, including attorney's fees, when a party has acted in bad faith, vexatiously, wantonly, or for oppressive reasons. Quoting Alaska Pipeline Service, the Wilderness Society, 1985. Courts have also found that falsely accusing opposing counsel of misconduct is sanctionable under Federal Rules of Civil Procedure 11. See Balerna v. Gilberti, District of Massachusetts, 2012, holding that Rule 11 sanctions were warranted where counsel made false accusations against opposing counsel. The McGarry v. Geriatric Facilities of Cape Cod, District of Massachusetts, 2011, plaintiff's conduct in making false allegations against defense counsel and Ms. Morris is in violation of Rule 11 of the Federal Rules of Civil Procedure. The judge didn't agree with you, dude. The judge did not agree with you. The judge did not agree with you. Paint Chip McGee. Oh my God, I love. Oh my God, y'all's names make me. Y'all's names make me laugh. They are hilarious. Isn't it from Alden here? Don't know. But thank you, Dwayne, for the 20 gifted Squid Pro Quo memberships. There will be another members only probably tomorrow afternoon. And hey, Dennis the Menace, how are you? Like, it's just he is arguing over things that he is doing. Unlike an email underlying the plaintiff's motion for sanctions, the plaintiff's false accusations was made in this case in a court filing and not a private email, in his capacity as counsel, not a litigant whose address had just been publicly doxed along with 9 others. It was an attack on the integrity of the undersigned, complete with a purposeful alteration of the cited excerpt from the defendant's memo to make it look like the false accusations were true. It necessitated a response ensuring the court was not misled on the issues before it, unlike the plaintiff's motion for sanctions, which has nothing to do with any proceedings, was filed without compliance with the local rule 7.1 certification requirement. What? You already called Daddy 3 times today, baby. Okay, you'll see Daddy in a couple of hours when he gets home, okay? Okay? I love you. Kiss. Kisses. I love you. I love you. Hey, I love you. Oh, thank you. He's just hey, Daisy May. Love the puppies. Oh my goodness. Look at the doggies. You see the doggies? Yeah. Yes. Oh my goodness. He's arguing. I can't state it. I feel like I'm redundant and I'm just repeating the same thing over and over again. But each paragraph is like you're arguing for things that you are doing. The plaintiff could have opposed the 12B1 motion without falsely accusing the undersigned of fabricating a quotation from a legal authority. He proved it. A direct attack on the integrity of the defendant's counsel to which he was compelled to respond. The plaintiff could have refrained from falsely suggesting that the undersigned independently contacted Whatnot to interfere with plaintiff's contract, another smear in the guise of evidence necessitating a response. The plaintiff could have opposed the 12B1 motion without distorting Amanda Martin's testimony and without rehearsing a prior false accusation that the defendant cited to non-existent legal authority in the prior 12B1 motion. These misrepresentations necessitated a response for which leave was granted and time expended to prepare and file, and which for an order to pay attorney's fees under 28 U.S. Code 1927 is warranted. Conclusion, is it acceptable for a party to falsely, unless it is acceptable, I almost read that wrong, for a party to falsely accuse an opposing lawyer of serious misconduct, such as fabricating authority, or unless the falsely accused lawyer's time responding to such a spurious attack on their integrity is of no value, the court should award the defendant a reasonable attorney fee to be paid by the plaintiff. Dennis the Menace, what's going on, bro? What's happening? Yeah, very doubtful he will win this motion. I just like I don't see the court taking this very well, especially when you basically say, unless it's acceptable for him to treat me like crap, which, like, the court should. He proved it. And obviously, yeah, and Karen, with that being said, he literally he was granted an extension of time to file that response to the sanctions and came up with this. I'm really hoping that the judge sees this as his response and doesn't take any other. Angel, you're not calling Daddy. You called Daddy 3 times already. He has to work. No. Did you hear? He has to work. No. Yes. Did this filing just show us how attorneys incriminate themselves? Yes, I believe it did. Chucky, you said it best. Confession through projection. Yep. So that's that. And I just have to make sure that I save this so that I make sure that I don't have to pay for it again, because they aren't expensive, but they add up quickly when you are looking for multiple documents. There we go. Okay, I did save it, so I can close this. Good. I don't like to have to pay for it twice, you know? Oh, and my arms are so sore today. Oh, like it's just, he argues again. Like, I keep saying it and I sound like a broken damn record, and I am sorry for that. But he basically tells us everything that he is doing himself. And I really hope the judge is like, well, that's your response to the motion for sanctions. If that's not what you wanted to do, I believe the judge will come out with a response by today. Like, that's also what I'm confused about. But I do understand every filing costs somebody money. So remember, nothing in this world is free. Somebody is always paying for it, whether it's the lawyer himself, the taxpayers. Somebody is always paying. Nothing is ever free. Just remember, nothing is ever free. Yes, I can't wait to the response to this. Do you think this will be the unhappy swan song of his career? He seems determined to crash and burn. He does, doesn't he? It's like he's self-sabotaging. And like, I can't. Yeah, he must have gotten his audacity at the Amazon Prime Day sale. Because people, free. Dennis, do you have Discord? Because you need to email me, because I'm confused. Are you okay? Like, not a joke. It's like, is everything okay? Like, message me if you need me. My email is on my page. My Google Voice number, I think, is on my page. Like, oh yes, yep. You if I always say when I describe something, if it sounds ridiculous, it's because it is. So, yeah. He is no joke. He's okay. He's no joke. Okay. Like, no, but like, okay. I do. Okay. Let me know if there's anything I can do, because I have no idea what's going on. Yeah, I have no idea what y'all are going on about. Paint Chips is in Florida. Who gave him the nickname Paint Chips? Like, there's so many things I do. Okay. Hey, Tammy. Dark Mage, the Lion, the Witch, and the audacity of this. Shizzy. Okay. Leave it to Shizzy to come up with the nicknames, because that's just his thing. Like, Shizzy is just the tug. Okay. Like, I haven't watched anybody else. I barely have, like I said, I barely have enough time to keep up with what I'm doing. Like, I've been working on this freaking reading through this Justin Baldoni lawsuit for like a week. 7 streams trying to get through this thing. And it's like, it's just, I barely have enough time to keep up on the cases that I'm actually following, let alone some stuff that's like getting more ridiculous and kind of giving me a all right. Well, Shizzy called the so-called journalist VPP. Oh, interesting. Whoa, what happened with there? Eating the paint chips in this prison cell. Oh, okay. Like that. Okay. That. Okay. I was like, Tug gave the nickname and Shizzy added it to a letter. Oh, okay. Like, y'all keep whatever you think of people. I've basically said leave me out of it. And when people don't leave me out of it is when I start, this is making my... Are you joking or are you serious with that? Because like the back of these 2 fingers, the front of this one, the back of these 2, and all the way up to my elbow, on the ulnar side, is sensitive to the touch. So if like this hurts, it's like poking a bruise, almost like a shingles kind of feeling, but not that painful. Like I can tolerate. No, it's fine. It's not just you. Y'all just... Doc 80 was factual. You plagiarized case text and worst of all misrepresented what it said, and the reply showed he had plagiarized. It's one of those things where I just don't understand the mentality with like the why. Like I just don't. It's not I don't get it. It seems like a waste of time, waste of resources, waste of money. Like all of this just seemed like a waste of money. I will I think she was supposed to. I don't think it happened. Hey, huge ass. How are you? I love that name. I love that name. Oh my God. And I don't mind saying it too, because it's funny as hell. Coming in late. We're in the middle of a blizzard. Lights are blinking occasionally, but comes back on 70 mile. Where are you at? Where are you at? Siberia? Like, oh, so I will, Malin, I will show you what got me called Hobbit feet. I just have to open up my photos and make sure that I don't, well, the certain people y'all are talking about aren't in Southampton, so there's that. So just a forewarning you, like it's not. Where is my photos? And Malin, it's really not that interesting. It's really not that interesting. When he was talking about his bike, I sent him a picture of my shoes. I sent him a picture. I sent him a picture of my shoes, and he called me Hobbit feet. It's like small feet and such a big butt. You wonder how I maintain my balance. So, Malin, it really wasn't that malicious. It was just, yeah. And it is 81 degrees outside here, which is why my chubby arms are in a tank top, because it is, yes, the thumbnail case is not federal. Depo was for a state case, not federal. So I am really not paying. I apologize for anybody who just got their eardrums blown out by that. She's watching a video of herself going down a slide at the park and absolutely losing it every time she plays it. And she is we're in a good mood today, but we're in a loud mood. We don't have an inside voice. Yeah. Hobbits actually have larger feet. Yeah, I don't have hairy feet. Yeah. Well, who's Elton? That's what I'm like. Who's Elton? Like, or what? We don't. Not sure. What? Whales and like never apologize for joy. Yeah, but it is loud, and I know that it can. When y'all are wearing headphones, it could it could blow out the eardrums, if you know what I mean. All right, so if the judge comes back with a decision, didn't realize kids had indoor voices. Yeah, it's a work in progress, you know. She's not even 3 yet, so I like hobbits. They don't take up much room. Oh, and this is why I love talking to my chat. So I wanted to get through that first before, before I veered too far off course, so that the people who just wanted to hear that stuff or the actual motion. If the judge comes back with a decision that's worthwhile, if it's just a denial, I'm not going to read it. But if it is if it's more than 1 page and it has any sort of Judge McDreamy snark in it, especially in the footnotes, definitely will be coming back to read it. I do have to go and cook dinner tonight on the menu of how we make food that the angel will eat, but is still decent for mommy's diet. And she moved she moved her chair over to the light switch. So this is why I don't turn on the overhead light, because it is harsh as hell. So this is my wait. You say no for nonsense drum. Yeah, I don't. Jeff, I don't. I agree with you. I'm. It's not welcome in this chat. Anybody who brings it up in this chat will be timed out for 24 hours, because I'm just like I'm done. Like I'm done. Y'all can keep that shit to Discord, to Twitter, to DMs on Facebook. I don't care, but just keep it out of here. This is supposed to be a place where we make fun of Bubbles. And like, because in this case, if y'all remember correctly, for those of you who don't remember or weren't here, I only started covering this case because Bruce threatened to call CPS on me. So I don't hate anybody on either side. I'm not particularly fond of the side that threatened me or decided to run their mouth about me. However, I am anti-Bubbles. Like I am not, I'm not pro like one side or the other. I am anti-Bubbles and make fun of the way things are written. Like, oh, what fell? Like, so I am here for the legal filings, and because there's a lot of people, and me included, who know little to nothing about the legal system. And I am always on we need to learn about our legal system. We need to learn. So when you hire a lawyer, you can know what questions to ask, how you can tell a good one from a bad one, as a layperson. And also keeping people accountable, because there is no accountability in this world anymore from anybody, especially our government. So when I trial watch, I'm generally anti-government. I'm critical of judges, generally speaking. I'm critical of prosecutors, because at the end of the day, prosecutors and the judge are on the same side. They're technically both actors of the state. So I'm all for holding people accountable. And the more transparency we have in our court system, and the more we read about our court system, the more we have to hold people accountable. So that's why I like to read stuff. Yeah, we are the anti-bubbles ecosystem. Yes. Don't matter about anybody else. I actually, with having Bubbles as their attorney, like, I almost feel for Lynette and John having to be represented by this, because if they were represented by an attorney who kept his mouth shut, yes, their case might not be great, but at least their attorney is not making them look worse. Right now, he is making them look worse than the facts of this case already seem to. The fun never ends. Yes, drama free zone. I don't care who likes who and who doesn't like who. I don't care. It's none of my business. It's none of my business. That sound like glass that broke. It was not. It was a pen falling on the floor at the same time as an empty can went from my desk to my filing cabinet. But because my printer is right here, it magically fell in between the two of them and rattled around, but did not fall. I couldn't do that. We couldn't do that again if we tried. I would try to keep it upright and the thing would fall over and spill, but it's technically they got what they paid for. I mean, not to say that I haven't had the time, like I said, I literally haven't had the time to watch anybody. Barely people are in the background. There's one, maybe two people that I actually watch, and that's mostly Charlotte Dobre and stuff in the background, Wilding Out, because it's hilarious. So, yeah. Damn it, if it's a drama-free girl, I'm going to struggle. Alas, poor York, I knew him well. I don't, but we can look. I was going to look later, but I can look now. It might take me a little, you should get a stream deck. I'm just working on keeping my head above water. But thank you to whoever mentioned it in the comments. Me being stupid and not unclicking parties in council and terminated parties when I look for documents, because that definitely saves a little bit of money every time. Thank y'all for that. All right, so there has been, there's another, wait one. So that was a document 104 that we just read. Okay, that was document 104. We have a document 105. Literally, we just read 104, correct? Y'all are with me. We just read document 104. You heard it here first. This is another, no, but this is not from the judge. This is not from the judge. This is document 105. And this is only 4 pages. It is a duplicate. If it's what I'm wondering what he took out. So I'm going to put document 104 and document 105 side by side and see why he filed it twice. Oh. Let's see here. Come on, Brucey Bruce. What'd you take out? Because this one's only 4 pages. The other one was 5. So something, yeah, it's deuce again, but like what is changed? Because this one was 5 pages. The one we just read was 5 pages, and the one we just read, he took out the first part. Wait. So I'm gonna share my it was funny. It was just funny. It was a joke. It was a joke. So there was no malicious intent behind it. It was a joke. So I'm going to share my entire window so y'all can see what I'm seeing. You had a stroke and can't remember squat. Well, I'm sorry. I didn't have a stroke, but I might as well have. So this was the original one. Or this was the original one, sorry. So look at the motion for attorney's fees. This is the first one, and this is the second one. So the motion for attorney's fees is different. I'm assuming a lot of it's the same, but the first paragraph is different. Documents 85 and 86. Yeah. So in this new one, he says the docs changed for what she is asking for sanctions. Hi, baby. There you go. Hey. This one says the defendant moves pursuant to 28 U.S. Code 1927 for an order that they pay the plaintiff reasonable attorney's fees as a sanction for unreasonably and vexatious multiplying proceedings by filing frivolous motions to dismiss or strike counterclaims. This is different. This one's the motions to dismiss or strike counterclaims, when this one is the fabricating quotations from legal authority. So it's interesting. Mama. I did too. Baby. Baby. You can't FaceTime Daddy. No. So this one, so he says the same thing in the memorandum of support, but the motion is different. Putting aside, so this was all the same. Black's Law Dictionary, what case he cited. Putting aside the suspect timing and the appearance of being hastily conceived, drafted, and filed to counter the defendant's filing of a motion for leave to reply to misrepresentations contained in the plaintiff's 12B1 opposition, the plaintiff's motion were based on the made-up premise that the counterclaims seek to add plaintiff's counsel as a party defendant. There was no argument that the motions were supported by some authority holding that by mentioning the plaintiff's counsel in the counterclaims allegations, it means he is a party defendant, despite not being so designated. The motion simply and falsely stated that the counterclaims named the plaintiff's counsel as a party defendant to fabricate a pretextual justification to file the motions when they did. It was an abuse of the court in this litigation. No, it was predictable. I agree that Randy shouldn't have filed it so fast, but it's like, Bruce, you're predictable. Like, yeah. It's I wouldn't doubt it. I really wouldn't doubt it. I just really wouldn't doubt it. The defendants waited 10 days to file their response, document 90, in a case that the court issued a no response necessary ruling. The court denied the motions the following day, document 91, stating, as defendant's response in opposition has confirmed and the court itself has concluded based on its review of the defendant's answer, no counterclaims have been asserted against plaintiff's counsel. Thus, there are no counterclaims against the plaintiff's counsel to dismiss. Thus, the court was waiting for the defendant's response to file before ruling on the plaintiff's motion, making it unavoidable that counsel will need to spend extra time to do so. Oh. Yeah, we're reading them. But that last paragraph was the same with the case he cited. Sorry, word finding. What he should have done is put this all in one motion. Because one, that would be cheaper, and two, that wouldn't look like you were being vexatious and filing unnecessary motions if you put it all in one. But no, you have to file it as multiple separate documents. Oh my goodness. This is always my, this was kind of my question, but at the same time, it costs money to file motions. Nothing's ever free. It's just who's paying for it. That's the, yeah, this is I know that's what we're getting. That's why we're reading it. This was the original one on the right. This is the one we're reading now. It is objectively unreasonable and vexatious to fabricate false pretext to justify filing motions to dismiss. Attorney's fees are warranted under 28 U.S. Code 1927 because the motions necessitated a response in the court's ruling, for thus multiplying proceedings. Yeah, this is a paper dump. That's all this is. It's a paper dump. Yeah. I think the judge is going to have a field day with all of this. Because the plaintiff's motions were unreasonable and vexatious multiplied proceedings, the court should award defendants a reasonable attorney's fees to be paid by the plaintiff. So there's that one. So I am going to see if there is another one. 2025, 319, second motion for attorney's fees. I'm just saving it so I don't have to buy it again. Because if I hit the back button to go back to the docket and then I click on this again, I have to pay another 40 cents. And it's not much, but it's 40 cents that I can spend on something else, like another document. All right. I'm just going to go back. And right now, that's all of them. Let's see. I'm looking through. Yes, and we're counting motions. Yes, I'm going to share the screen. Hey, baby. Help you what? Call daddy? We're not doing that again. We're not doing that again. So this is the yeah, we're definitely not calling that. Here we go. Going back all the way, the first one. These are when they were pro bono, or pro se, sorry. Exactly a year ago today. Motion to dismiss. Then the motions or defendant's motion for appointment of counsel. 15 is the pro hoc vice motion by Bruce. That's 9-4. So we're going to go after that. That was the order. Bruce has filed. I got to write these down because if I don't write these down, we're going to get confused because there's a lot. Angel, what's up, baby? Oi. Oh. If you I will help you pay for documents when you're going to get them. I'm billed every quarter, so I won't be billed for this until March or the end of March. So, yeah, this dude is unhinged. I agree with you, Clarence. What do you need help with? You can't call Daddy, baby. I'm sorry. When he gets off of work, we will call him when he is on his way home, okay? Okay. She just wants to, all day long, she just wants to call Daddy. She wants to call Daddy. Debbie's trying to be the teacher's pet. Stop, Stephen. All right. We are going to see. So, 17 was Bruce. 18 was Bruce. 19 and 20 were Bruce. 21 is Bruce. And I have my favorites. Thank you for the 1999 super chat. You are super, y'all awesome. I'm writing B and R for Bruce and Randy and just Talene. And Patrick, thank you for the $5 super chat. Just gonna say, fuck the third, get in here now. The marshals will have you here by 9 a.m. tomorrow. But that's a free ride. Or that's a ride paid by the taxpayers. And I don't know about y'all, but I don't want to pay anything for Bruce. Oy, boy, oy, oy. Is somebody causing trouble? I don't. I'm a stay-at-home mom, you dumb cunt. No, there is no babysitter. This is my daughter. I am a stay-at-home mom. And unfortunately, for you, she is way more important than you will ever be, bitch. So you can fucking leave. Bye, bitch. Bye. Oh, she's timed out for at least 5 minutes, I think. But I am a stay-at-home mom. Go F yourself, lady. This is my daughter. If you don't like it, no one's forcing you to be here. I'm not tying you to a chair, making you watch my videos. You don't like my daughter? And sometimes, yeah, she does interrupt the stream. But guess what? I got 2 of those for you. But thanks for the view and the watch hours. I appreciate it. And the engagement. You're sweet pea. Thank you for the ad revenue. By her or by me? Because I wasn't the nicest with the response. But, you know. Like... And sometimes I do wish I had a babysitter. Oh, yes. We, 3 Finger Play, we read document 105. If you back up like 10 minutes, I read document 105 and compared it to 104 to make sure that it was different instead of just, yeah, it's called Real Life. What a Karen. No offense to, you know, Karen's books. The good one. We had a hater in the house. We had a hater in the house. Let's get him. Let's get him. Like, and yes, sometimes she does get a little bit, you know. Well, you dropped it. Not my fault. Sometimes she does get a little like, girl, you need to sit down. Well, I don't know what you want me to do. She's just mad because she can't call Daddy. Well said. Hey, Mom, you want to FaceTime her? Okay. You want to FaceTime Nana? Yay. Where'd you put Mommy's phone? Where'd you put Mommy's phone? Oh, no is right. Go get Mommy's phone. Oh, here. Baby. Oh, I don't know, baby. You lost it. You lost my phone. Oh, the battery is dead on that one. Apparently it wasn't charging like we thought it was. I'm sorry. You lost. Sorry. Oh, right here. Hold on. Sorry, guys. Got to mute for a second while I call my mother. She gets to FaceTime someone. She's happy. Like, oh, there, Diana. You happy? Girl, get a life. And I'm sorry if y'all don't like my stream. I love you guys and I appreciate you being here, but like no one's forcing you to be here. Like no one's forcing you to be here. Like y'all just like Ellen, please don't be a Diane. Oh no. What happened? Well, guess what? I'm a stay-at-home mom. So guess what? My crying baby comes first. And if y'all don't like the fact that I have a crying baby, you can leave too. Here, I'll do it for you. There you go. Bye. Like, ish. Thank you. Yeah, and off you flock. No, see, over here, we're just like off you fuck. Sorry. Yeah, and people, yeah. Good if I'll send you, yeah. Debbie, you don't have to do that, but thank you so much. Like, I appreciate that. Yeah, this is the thing. Like, I didn't know that person existed 5 seconds before he commented, and I still don't. So, like, I love the people who spend time in this chat, and I get to know them. But at the end of the day, like, y'all are behind a keyboard, and I'm not. So, at the end of the day, like, I don't know who most of you are, and that's okay. I can't know who everybody is, but he said it like I'm supposed to care. And I do, in a way, but like, that's why there's so many channels on YouTube covering so many different things, because not everybody is for not every streamer is for every person. And that's okay. New term of the day. Don't be a Diane. Karens, you have been outdone. Ninja Puppy, thank you for the $9.99 super chat to help with your pacer fees and maybe a leftover for a nanner for baby squids. Thank you. Haters, y'all need to have an ounce of kindness and not be such Karens. I will stump you. And thank you, Captain Karen. You're my ride or die. So you can tell who isn't a parent, but if they are, I feel sorry for the child. Bless y'all's hearts. I'm gonna pray for your family because they have to deal with you. At the end of the day, I just time you out and I move on. And your family is stuck with you. What do they say? You can pick your nose, but you can't pick your family. Sorry. Oh, I'm glad I make somebody laugh. Yeah, baby squid is part of this programming. At the end of the day, I am a stay-at-home mom. So the reason that I am able to YouTube during the day and because I am a stay-at-home mom. It is what it is, you know? You can Jeffrey, you can pick your friends and you can pick your nose, but you can't pick your friend's nose. Oh my goodness. Hey Kano, how are you? All right, let's get back to this motions that we were working on. We were up to 5 with Bruce from so 1, 2 motion 3, 4, 21 was Bruce. Hey, we finally got one from Randy. And I can't believe I'm doing this, but somebody needs to. Order plaintiff, that's Randy. And I'm glad that y'all are here doing this with me. We have another Randy, because I'd probably lose my mind if I was doing this all by myself. I would probably like give up halfway through. That's another one for Bruce. Scheduling order, Randy. Randy. So far, we're pretty even. So far. Motion for Bruce. Order. Notice of telephonic hearing. Memorandum, conference calls, instructions. Moon and entry. Final scheduling order motion from Bruce. Act required motion from Bruce. First motion to amend, Randy. Order response by Bruce. Oh, Bruce, you're taking the lead. Order set deadline motion. Bruce. Order notice of redeposition response Randy. Randy's coming back strong. Action required duplicate order. Okay. Bruce, just when you think Randy's going to catch up. Randy. Oh. So that was Randy. That was Bruce. Order motion Bruce. Which I actually agreed with this. Motion to excuse mandatory mediation. I actually agreed with that because we all know that this is not going to get anywhere. Order. Response by Bruce. Bruce. And I'm going to have to go back and double check this because I might be off by one. Order. Response by Randy. Order motion to dismiss Bruce. Bruce. Randy. She repeated after me and she said, Bruce. 72 is Bruce. Stricken. These were filed by Randy, but they were stricken. So technically I'm going to count them, but we're going to count them off to the side so that, because technically they don't matter. 2, 3, 4, 5. There we go. Motion for reconsideration to transfer the case to Gainesville. I wonder who filed that one. Randy. Order. Motion for reconsideration to compel. Bruce. Bruce. And I know there's probably an easier way to do this, but I don't know it right now. So we're just going to have to do it the long way. 87 is Bruce. Order response by Bruce. Is anybody sick of me saying Bruce yet? I do apologize, but I have to say it out loud. Otherwise, I'm not going to remember, or I'm not going to write it under the right person. Action required, order, status report, status report, motion for sanctions by Jeremy. That's a good one. Order to show cause. Ooh, that's going to be a good one. Motion to strike by Bruce. Response by Randy. Motion for attorney's fees by Bruce. Another Bruce. All right, we want the final totals. Do we want the final totals? Oh, and there's been a lot of chat since I've been doing that. Let's just say BBB wins this one. All right. Was anybody sick of me saying Bruce? I do apologize. I just have to. Yeah. Search the saved documents for Gainesville division. That's true. All right, Bruce was 5'10", and I might be one off on this, so I will do it again after I'm done to make sure that I'm right. Hey, Grizzy. 30. Yeah, anybody have 35? Like, okay, Clarence, 35 to 22. And I'm going to include the stricken ones just because they were originally filed by Randy. Like, hey, Dangerous Waves. All right. All right. 5, 10, 15, 20, 25, 30 by Bruce. And 5, 10, 15, 20, 24 by Randy. And that includes 5 that were struck from the record. So, yeah. Hey, Dennis, bro, I like you, but this is not the place for whatever issues that you have. You need to take care of something. You do you. I'm not like telling you not to do anything, but like just here. BM is doing his polyflop doc. 73, 77 will be refiled in May. Like, when are we fighting to the death? Today. No, I'm kidding. Text me, but don't call me. Like, yeah, it sounds like more like Bruce's polyflop. Yeah. Dennis, I told you, I've warned everybody multiple times to stop bringing stuff up in my chat. This is where we don't do your drama. This is your last warning that I will time you out because you don't have to like people and that is fine, but leave it out of here. That's all I ask. Yeah, right here. That doesn't include the pro se. If you want to include those, if you want to include the pro se documents, we can. I'm not going to officially count them, but Slug stopped. I told Slug to text me and he did. So if we want, I didn't include the documents, any documents before Bruce filed that pro hoc vice motion, and I did not even include the pro hoc vice motion because that was required. That was not, multiplying proceedings. That was just has to be done. It would not get him in trouble, and it would. All AI would love to see is for Randy to respond with one word: polymop. It's more like polyflop. Whoever said that. So if we're counting the ones before Bruce officially came on, obviously the complaint, the summons, and this leans a little towards Randy because there's things he has to file. The complaint, the civil cover sheet, and the summons automatically have to be filed. Those aren't like, Hi, baby. Hi. I'm coming. 1, 2, summons issued. 1, motion to dismiss. Yeah, and no offense to anybody who's pro se, but it's very hard to know the legal system as a pro se defendant. So knowing what to write or knowing to write due to lack of jurisdiction, somebody was helping you. Somebody was obviously helping you. Corporate disclosure statement. Memorandum in opposition to dismiss. All the other ones, they're before Randy, before Bruce officially became in, was more Randy than John and Lynette. So, hi. Oh, you dropped my phone. Okay. So after that, it's 30 to 24. So that's what we it's 30 to 24. But that's crap is better than polyflop. Continuously repeating the acronym polyflop. Okay, Sir Frank, you win. I hope you're doing well today. I think with that, I'm just going to check one more time to make sure that this is all we've got, and we don't have a 106. Okay, we are good. I haven't. I know nothing. I know little to nothing about any of those new players. All I pay attention to is this. Like, all I pay attention to in this is the actual documents, because at the end of the day, I'm just anti-Bubbles. I don't pay much attention to anything else. That's why when y'all tell me stuff, I'm like, really? I had no idea, because I really don't. Like, I barely have enough time to keep up with what I want to keep up with. And it's, yeah. So, are you ready to go play? Okay. We are going to probably head to the park for a couple minutes. I will see you guys on the next one. Thanks for hanging out with me. And even thanks to the haters for giving me some, extra entertainment for today. Hey, Gabby, how are you? It's good to see you. All right. Y'all, it's one thing to be pro se in small claims, but for major civil and criminal, it's foolish. Yeah, but at that point, I really don't think they had a choice, though. Yeah, we'll park fun. We're close to the park now. And Nana's FaceTiming because she hung up. So y'all have a great day. I got to make sure I got all these. And Three Finger Clay, thanks for the $1.99 super chat. New doctors posted. We got that. Ninja Puppy, we got yours with the Banana Fund. And then Clarence, thank you for the $1.99 super chat. Have a feeling the judge is going to be pissed. Yeah, I have a feeling that you are correct. I have a feeling that the judge is going to say this motion is not taken well. Oh my goodness. Still, and if you need anything, let me know. I know you're long distance, but y'all, Stroke was my favorite people to work with because I saw the most improvement, and they seem to care the most about participating. So participate in your therapy. I hope you get better, and I hope you recover as much as you can. So yeah, Bubbles is his own worst attorney. Yes, like much less for anyone else. He argues against himself, and I sound like a broken record saying it, but it is what it is. Like, and y'all, I didn't have a stroke, but they were my favorite population of patients to work with because they just, Y'all have a great day. I will see you guys on the next one. Probably tomorrow morning, we are going to try and make it through that damn motion for Justin Baldoni and the toxic masculinity versus the toxic femininity. Holy, so dramatic. So dramatic. Y'all have a great day. Bye, guys.